Very well. If we can please go on the record, let the record reflect that this is case number 2013 CR 0671, State of Ohio versus Carla Hague. Can everyone hear me? Am I speaking loud enough? The microphone's picking it up. Very good. Thank you. Let the record reflect that present in the courtroom, representing the State of Ohio, are attorneys Paul Scarcella and Leigh. Let the record also reflect that present in the courtroom, representing the defendant, which is attorney William Bobalski, and finally let the record reflect that present in the courtroom is the defendant, Ms. Carla Hague. Before we go any further, Attorney Scarcella, Attorney Baer, who should I call on in regard to the State of Ohio?
Ms. Baer, Your Honor.
Very, very well. Ms. Baer, it's my understanding that you have a motion for me. Is that correct?
That is correct, Your Honor. Your Honor, I believe the court does actually have the motion in front of it already. It is the state's understanding that Ms. Hague would like to withdraw her general pleas of not guilty to the 2 counts contamination of, she would be entering a plea of guilty to a stipulated lesser included offense of count 2, attempted murder, so the new count would be felonious assault. This is pursuant to 2903.11 of the Ohio Revised Code, a felony of the 2nd degree. Pursuant to the plea agreement, the state would be dismissing count 1.
Ms. Hague, I have in front of me a document entitled Written Plea of Guilty. This document consists of 3 pages, and on the last page it appears to have your signature. Is that in fact your signature?
That's correct, Your Honor.
Ms. Hague, are you under the influence of any alcohol or drugs this afternoon?
No, Your Honor.
Now, I've read some materials, and I understand that you have not ingested any alcohol since, I believe it was sometime in 1997. Are you currently on any medication?
Yes, I am.
And what is the nature of that medication?
I'm on thyroid medication. I'm on medication for asthma. And I'm on Ativan for nerves.
Is it anything which affects your ability to understand what I'm going to say to you this afternoon, what you've heard Attorney Baer recite, what you and Mr. Bobalski have been talking about over, I know, a long period of time? Do you feel that that medication in any way affects your ability to understand what is happening?
No, Your Honor.
And do you have any concerns in regard to that, Mr. Bobalski? I do not. Very well. Ms. Hague, are you a citizen of the United States?
I am, Your Honor.
Are you able to read and understand the English language?
I am, Your Honor.
And I do understand that you do have a college degree, and actually you have a nursing degree. Is that correct?
That's correct, Your Honor.
Are you currently on felony parole or felony probation?
No.
And do you understand that if you plead guilty or are found guilty of the crime in this case, that you'll be subject to DNA testing, and that under the laws of the United States you would not ever be allowed to own or possess a firearm?
I understand, Your Honor.
Ms. Hague, before you signed the document that you and I initially discussed, did you have the opportunity to read that document, or did your attorney read it to you?
Yes, Your Honor.
And after either you read it or your attorney read it to you, did you have the opportunity to ask your attorney any questions that you had, so that you were sure that you understood that document, its contents, and how those contents relate to you?
Yes, Your Honor.
Do you have any unanswered questions?
No, Your Honor.
It's also my understanding that Attorney Bobalski has been representing you during the period of time that the original charges and now this amended charge have been pending. Is that correct?
Yes, Your Honor.
And during that period of time, have you been able to meet with Attorney Bobalski to give to him your version of the incidents that led up to this amended charge?
Yes, Your Honor.
And during that period of time, have you been able to satisfy yourself that Attorney Bobalski has been devoting to your case the amount of time that you feel is necessary and proper?
Yes, Your Honor.
Are you satisfied with the quality of legal services which you have received from Attorney Bobalski?
Very much so, Your Honor.
Ms. Hague, as you have heard, you were charged with 1 count of the crime of felonious assault, which is a felony of the 2nd degree. It is alleged that between the time of September the 12th, on or about the 12th day of September through on or about the 15th day of September, you did knowingly cause serious physical harm to another, Charles Hague, by placing antifreeze in his wine. Do you understand that?
Yes, I do, Your Honor.
Felony of the second degree, as Attorney Bear has alluded to, can be punished by a prison term of 2 to 8 years in whole years. Additionally, you could be required to pay the cost of these proceedings and to pay a fine up to $15,000. We're going to get into a lot more detail in just a minute. But Ms. Hague, do you understand the nature of the charge pending against you and the penalties, including prison term that could be imposed?
Yes, I do, Your Honor.
Now, this is a good time for us to talk about this. As you've heard it alluded to, I have received a joint recommendation from the state of Ohio and from your attorney that I sentence you to a 2-year prison term. You would be credited for any jail time served. You'd be credited with the time that you spent in the Ashtabula County Jail. And you'd be given credit for any time that you would spend before you go to prison in the Ashtabula County Jail, and you'd also, obviously, that would go against the 2 years. I would require you to pay the cost of these proceedings, and I would also fine you in the amount of $12,500. At the time that you began with your state of prison term, and that additional period of time could also be run consecutively with any other prison term which you were served. You understand that?
Yes, yes, Your Honor.
And the court reporter doesn't have the ability to record a nodding of the head, so if it wouldn't be too much trouble, I realize it's a little bit different because I'm looking at you, you can see me, and I can see you, but if you'd please say yes or no. Do you understand that?
I do, Your Honor.
You would also be entitled to earn days of credit pursuant to Ohio Revised Code 2967.193. Days of credit are not automatically awarded, rather they must be earned, and there is a limitation on the number of days that you can earn. Do you understand that?
Yes, Your Honor.
Even though I would be sending you to prison for 2 years, I will state on the record that I will entertain a motion for judicial release after you have served 6 full months in prison. By that I mean the time I said you would be given credit for the days that you served in the Ashtabula County Jail does not apply against the 6 months. It applies against the 2 years. To do at the time that I received that motion, after the 6 months have passed, I will get in touch with the institution and I will see if you have had any infractions of the rules. If you get to prison, you'll learn that they call those tickets. If you have any tickets, 1, 2, 3, I don't care how many, I don't care what they're for, I will not bring you home. You will serve the full.
I understand, Your Honor.
If I do bring you home, I do put you on judicial release, you will be on probation for 5 years. You need to understand that if it is alleged that subsequent improvement you violated the terms and conditions of your judicial release, you come back in front of me for a hearing. And I would have one of 2 choices. I couldn't make your judicial release any longer because 5 years is enough. But I could make it more restrictive, or I could return you to prison and you would serve the balance of your term until you serve the full 2 years. Not in prison, you'd be given credit for the jail time served against that 2 years, but you would go back and serve whatever time was left in that 2 years. Do you understand that?
I understand, Your Honor.
Has anyone threatened you in any way?
No, Your Honor.
Do you understand that a plea of guilty by you is a complete admission by you of your guilt to this charge? In other words, you're saying, Judge, I did it. Do you understand that?
Yes, I understand.
I now need you to tell me what you did, Mrs. Hague.
In September, I made the terrible decision to put a chemical into a drink that my husband would consume.
Do you need a glass of water?
I knew it could make him ill. The circumstances were that I thought he would stop using the drink. I was wrong in that decision, and I take full responsibility for that decision. When I did it, I thought it was the right thing to do. I know that I let circumstances from which I was suffering overcome my good sense. I deeply regret everything that resulted.
Take your time, Mrs. Hague. We have all the time that you need.
And I beg the forgiveness of my husband, children, and my grandchildren. And this I ask from the bottom of my heart. Oh, that's all, Your Honor.
Thank you very much. Now, Mr. Bobulski, I know that in just a few minutes you're going to have some things for me. And I've had the opportunity to read what we're going to put as part of the record. Do you have any questions about the competency of your client to stand trial and that she does not understand the nature of the proceedings or cannot participate in her defense?
I do not, Your Honor. I base that upon my own observations and judgment, as well as the judgment of the professionals that we have had in the evaluation phase of this case.
If I were to sentence you to something that was not within the guidelines, then you could appeal that. But this is obviously within the guidelines. You also understand that in one of those types of trials, you have the right to remain silent, could not be made to testify, and that the fact that you did not testify could not be commented upon in any manner or held against you. Do you understand that right?
I understand that right.
Do you waive that right?
I waive that right.
And finally, do you understand that either one of those types of trials, it would be the duty, the burden upon the state of Ohio to prove each and every element of the crime with which you're charged beyond a reasonable doubt? Do you understand that right?
I understand that right.
Do you waive that right?
I waive that right.
Now, counsel, I know that each one of you have materials that you want to bring to my attention, witnesses that you want to bring to my attention in regard to the sentencing. And what I plan on doing is that during that sentencing hearing, going to go pursuant to 29-29-11 and 29-29-12, the sentencing guidelines and balancing the seriousness and recidivism factors. And at that point in time, you'll have everything. You'll have time to bring anything to my attention that you want to. Is there anything else that anyone wants to bring to my attention before I ask Ms. Hague how she pleads? State of Ohio, Attorney Bear?
Nothing further from the state, thank you.
Attorney Bobulski?
Nothing else, Your Honor.
Very well. Ms. Hague, in regard to one count of the crime of felonious assault, which is felony of the second degree, how do you plead? Guilty or not guilty?
I plead guilty, Your Honor.
Very well. The court accepts your plea of guilty, the court finds you guilty, and the court finds that your plea is knowingly, voluntarily, and intelligently made. And even though this is a negotiated plea, we now move to the sentencing portion of the hearing. I'm going to be very interested in anything which either you or your attorney wish to bring to my attention. But I'm first going to call upon the state of Ohio. So if you and Mr. Bobulski want to sit down, I want to, as I've already alluded to, I believe that there's some matters or some witnesses that the state of Ohio wants to call. And I want you all to be able to sit down while we're doing that. Hey, Attorney Bear.
Thank you, Your Honor. This case is one that I think I can relate to the court. It's been a very difficult struggle for this entire family since the night this happened. This family has a very emotional issue of having a mother and a father in this situation where their father was victimized in such an extreme way. The night that this occurred, Carla had called her son to help put her father back, or put his father back into bed, and didn't call 911. And as soon as the son came over to the house, he called 911 knowing that there was something severely wrong with his father. The judge was then taken to the hospital, and eventually he had to be life-flighted to the Cleveland Clinic.
May it please the court. Judge Brown, I am 72 years old. And in my 72 years old, I've weathered a lot of storms, as I'm sure you have. This is the biggest one. But I'm going to weather it, and I'm going to try to lead my family, my children, and my grandchildren through this. My son now lives with me at my home. Every one of us, including myself, are in psychological counseling of one form or another. My oldest granddaughter has been in my youth detention center on 3 separate occasions since this incident occurred. And she's been there because her behavior is uncontrollable, as she cannot understand why and what her grandmother did. But I want you to know that I bear no anger or animosity to Carla. I am beyond that. I want to live the rest of my life happily. I want to live the rest of my life by putting one foot ahead of the other. And I'm going to do that. It is very important to me and my family to have this huge black spot behind us. Today is the day that that's going to happen. I hope that Carla can get on with her life as we are going to get on with ours. With that being said, I concur and endorse 100% the recommendation of the state of Ohio, jointly with Carla's attorney and Carla herself, as to the plea bargain and the sentencing recommendation. And please excuse me for not wearing a tie, but my breathing issues make it much easier to finish this kind of a talk without one. Thank you.
And thank you, sir, and I certainly understand that, and I appreciate your coming this afternoon. I know you've just expressed this difficult for you and your entire family, and I'm sure that's the case. Thank you.
Thank you.
Good afternoon. My name is Maury. I'm Carla and Chuck's daughter. I'm the oldest of 3. As a child, you look up to your mother for guidance, for advice, approval, protection, and to know the difference between right and wrong.
Take your time. You have plenty of time.
All I wanted in life was to make my parents proud and to show them that I'm a good kid. And I can do it on my own. I'm so very saddened and disappointed in what has happened. I'm sad that I was put in positions that I didn't need to be put into. I'm sorry that I had to choose between my mom and my dad, but I was doing the right thing. I love them both, but I had to do what was right. What my mom did was wrong, and hopefully one day I can find forgiveness. That's all I have to say.
Thank you very much.
Your Honor, we have the Hague's other daughter.
Good afternoon.
Good afternoon, Your Honor. I'm Kirsten. I'm the youngest of the 3. And I just want to say that neither my mom nor my dad are bad people. We love you both with all of our hearts. Obviously, this is more than just an antifreeze issue. We've had a dysfunctional family years prior to this, unfortunately. And I just want to say that I'm hoping this can be the start of the family healing. Maybe this can be the start of bringing everyone back together. And I know my sister, my brother, and myself, we love both mom and dad. And thank you for everything you've done. Mr. Wolsey's been incredible. Brett, Sheriff Johnson, everyone has just been, treated our family with upper class, and we just really appreciate that. We appreciate everyone being there, supporting our family.
Thank you very much again. I know this is very difficult, and I appreciate your coming this afternoon. Thank you.
As the court has stated, a woman at this time of 71 years of age, who has been married for 45 years, who has 3 grown children, 2 of them the court has heard from. Your Honor, this is a question of how did we get at age 71 from those decades of that service to the family, to her profession, to her church, to that point in September of 2013. And I submit to the court, and it is referenced. This does not amount to what I suggest to the court makes this go away. This is not a argument or suggestion to the court. First, it isn't an argument that it didn't happen. Your Honor, there was a complex developing issue of depression, anxiety, and fear that Mrs. Hague was in the process of losing her husband. Now, that loss is not something that anyone asks this court to speculate about. His severe condition of pulmonary fibrosis.
In regard to 292912C, these are factors which indicate that the offender is likely to commit future crimes. I do not see any one of those 5 factors present here. Does the state of Ohio?
Your Honor, we agree with the court.
There is no prior criminal record. The offense was committed under circumstances not likely to reoccur, and most importantly to me, as a judge, that I always look for, is that the offender shows genuine remorse for the offense. So I am going to accept the joint recommendation of the counsel for the state of Ohio and the counsel for the defense. And Mrs. Hague, it is the sentence of this court that you serve a 2-year prison term. You are to be given credit for jail time served. You are required to pay the cost of these proceedings. You're also required to pay a fine of $12,500. I need to remind you again that at the time that you complete your prison term, the Adult Parole Authority will place you on a period of mandatory 3 years post-release control. And that is important because if it is alleged and subsequently proven that you did in fact violate the terms and conditions of your post-release control can be revoked, can be returned to prison even though you served your full stated prison term. I'm also going to put on the record that if I receive something from the warden in regard to transitional control or boot camp, I'm going to deny it. I want her to stay in prison for 6 months, so I would not approve that. I'm not going to have you taken into custody this afternoon. And the reason I'm going to do that is that Mr. Bobolski has told me that there are some loose ends that you need to tie up, and I want you to be able to take care of those. But most importantly, I want a pre-sentence investigation report prepared. If I was going to place you on community control, I couldn't sentence you until that PSI had been prepared. But since I'm not putting you on community control, since I'm sending you to prison, I'm stating to you that on or before 9 o'clock in the morning on Friday, June 27, 2014, you are to report to the Ashtabula County Sheriff's Department to be taken into custody, and then you will be transported by them to a processing center, and then ultimately, I would imagine, to McMurraysville.
That's all, Your Honor.
Anything else, counsel, in the state of Ohio?
Nothing further, thank you, Judge.
Hey, Attorney Bobo.
That's all, Your Honor. Thank you.
Very well. With that, then, we are off the record. These proceedings are concluded.
All rise.